All right, we are live. It is Monday, June the 9th, 2025. And the topic that we are doing today is maintain status. Just to provide a brief introduction as to who we are. My name's Stephen Meurrens. Joining me today is Nicole Chan. We are both lawyers at Larlee Rosenberg. The topic that we are doing, as I just mentioned, is maintain status, and this again is based on a recent program delivery update. Program delivery updates, for those who don't know, are when IRCC updates its internal guidance. So as you can see, as you can see on the screen here, I believe it was last week that IRCC, May 28, 2025, that IRCC provided updates to its maintained status guidance. Nicole, do you want to just provide a brief overview as to what maintained status is in general before we dive into the specific guidance?
Yeah, sure. So it used to be called implied status. Maybe if you were reading up on this a couple years ago, you would have seen that it was previously called implied status. It's now called maintained status, and that switch was made a couple years back. Essentially, if you are in Canada on temporary resident status, and before your status in Canada expires, you submit an application to IRCC to extend your temporary resident status. You are afforded something called maintained status if your extension application takes longer to process and your valid legal status expires in that meantime during the processing. So to give an example, let's say if my status were to expire on June 9th and I submitted a work permit extension application on June 1st, and that work permit application is going to take, 6 months to process. When June 9th hits and my current work permit expires, I transition onto maintained status. I hope that makes sense.
Yeah, made sense to me. If anyone has any questions or anything, they are free to go to our YouTube channel or on X, where this is being streamed, to ask. What I'm going to throw up onto the screen now are the specific changes. So here we go, the overview of maintained status. And there are some big changes as of May 28, and thank you to people who submitted questions in advance. We're going to answer the questions at the end. As Nicole was saying, is that everyone must leave Canada at the end of the period authorized for their stay. Section 181 of the Immigration and Refugee Protection Regulations provides that someone in Canada can apply to extend their stay or their status before it expires. If they do so, then the period of their stay is extended by law until a decision is made, and that they have this status only as long as they remain in Canada. This creates a big headache for those who are, say, extending their status as workers and may have to go on business trips because they are able to stay in Canada beyond the period authorized for their stay as long as they applied to extend their stay before, but they cannot leave Canada. And this is a constant sore point, especially what's the current processing time for work permit extensions? Over 200 days.
Yeah, over 200 days, 6 to 7 months.
So during that period, if someone has to have a business trip or something, they cannot leave Canada and come back and continue working. They'll either have to apply for a new work permit or something like that. And the provision that actually provides that someone can continue working until a decision is made is Section 186U of the regulations. This is a key point here, that if someone did have a work permit and they were switching to visitor or student, then they don't get to continue working while they are on maintained status because they applied to change their stay. The basic principle is that 186U only provides that someone can work without a work permit while on maintained status if they applied to extend their stay as a worker. And it's the same thing for study permit holders. Do you want to touch on the rule for TRPs in maintained status?
Sure. So I don't know if people know what TRPs are, but I'll explain really briefly. TRPs are something that you get if you want to enter Canada temporarily, but you are otherwise inadmissible to come in. And we see a lot of these for people that have previous criminal charges or convictions, or are otherwise unable to enter Canada. We also see it for people that are out of status that are in Canada that want to stay here. Essentially, the legislation says that if you are in Canada on an existing TRP and you want to continue staying here, you can apply for a new TRP, but they're not treated as an extension application the same way that a work permit or a study permit extension application is. And so you don't actually get maintained status because of that. It's kind of, yeah, it's a little bit confusing.
It's super confusing. It leads to a lot of, I guess, refusals, you can say, or people who thought they were on maintained status and they weren't. Date and time of receipt of application. I believe this was one of the changes, just affirming this. It's one of the quirky aspects of Canadian immigration law is that IRCC uses universal time zone, Greenwich Mean Time out in the UK. King Charles is our head of state, I guess. And the result is that if an application, an extension application, is received after midnight, UTC on the date of expiry, they do not benefit from maintained status. That can result in a bit of oddity in that someone on the West Coast will have to apply to extend their status about 3 hours earlier than someone in Toronto, because it's not the local time zone that matters, it is UTC. I'm not actually aware of any refusals around this. I don't know if it's just because people are submitting their applications on time. And I'm also not aware of any judicial reviews or challenges to this. I personally think that if an application is refused under this, that it would be ripe for challenge. But yeah, I'm not aware of any refusals on this. Are you? Or
No, I actually had to do this once.
had to do what once? Get it in the morning?
Yeah, get it in right before midnight UTC on the day the status was expiring. That was interesting.
Yeah, it's a very, very weird rule.
Yeah.
Travel outside Canada, we talked about this. They may be able to re-enter Canada, but they cannot resume working. Pretty much as short as that. I don't think there was any other notices or big changes here. And this just reiterates they may not resume work or study in Canada. I'm surprised that there has not ever been a change to this because of how odd it is. Now, I should note that there are those who receive the interim work authorization letters if they're changing employers. And so there's been some discussion as to whether they will be able to continue working under the interim work authorization. I'm not aware of any firm IRCC pronouncement on this. If an application is approved, then obviously they get their extension until the new period. If it is refused, then they have 90 days to apply to extend their status from the time that they lose their status. So I get asked on occasion, does the 90 days start when the work permit expires, say, or when someone's maintained status ends? And it is when someone's maintained status ends. Gets a little bit complicated if it's bounced under R10. But even there, I find that the letters generally say that someone gets maintained status as of a date of the refusal. So here is the big part, I believe, that changed and has caused a lot of confusion. Do you want to describe briefly how it used to be before with the piggybacking?
Yeah, so I guess if you go into the Wayback Machine, you can find the previous iteration of this policy, and it basically the consensus is that it used to be if you applied, and I'll give an example for this. Let's say my work permit expires on June 1st, and I submit a work permit extension application on May 30th. Then I get maintained status, right? Subsequently. And then let's say, I thought, I'm not sure if my work permit extension is going to be approved. I don't want to hedge my bets on that. I want to do something else as well. And on June 5th, which is after my status has expired, while I'm on maintained status, I then submit a visitor record application, which, if you're familiar with those, if granted, they'll give me visitor status in Canada, but not worker status, right? So I'm doing this because I'm afraid that my work permit extension is going to get refused. So in this case, I have a work permit application that I submitted while I was still in status that extended my status in Canada. And then I have a visitor record application that I submitted after my status had expired while I was on maintained status. So the old iteration of the policy said, even if the work permit extension application was subsequently refused, the visitor record application that I submitted during maintained status is still going to be valid and active, and a visa officer can adjudicate on it. And I would still also, this is important, be granted maintained status. Like, I'd still be allowed to stay in Canada during the time that my visitor record is in processing and waiting for it to be adjudicated. So you used to be able to daisy chain it that way because you would still get maintained status on applications that you submitted during maintained status. And that's the big change that's come out now.
Yeah. So the current, and as a lawyer at our firm said during one of our recent monthly meetings, there was like a bunch of confusing stuff about the old rules. They tried to clarify it, and it's now super confusing again. So we'll just go through it. So an applicant only maintains their temporary resident status during the processing period of their application if they submit the application before the expiry of their status. That much is clear. If an application is submitted before the expiry date but is determined to be incomplete, then it is returned and they no longer benefit from maintained status. If circumstances arise during the processing period that the applicant determines would impact their application, they may submit a subsequent application for extension detailing the new circumstances. That, as we discussed at the firm, it's not clear if they're trying to say that you can no longer just update applications and try to change employers in the same application, change processing categories in the same application. As one lawyer at the firm pointed out, it doesn't say that you can't. It just says that there's this option to instead apply for a new permit. The thing with applying for a new permit, as we'll get to below, is that if the first extension application is refused, then the subsequent applications may be also. So here's if the first application is refused and the applicant submits their subsequent application for extension before the expiry of the status, they maintain their status. Here's the part that changes, getting rid of the piggybacking or daisy chaining. If the applicant submits their subsequent application for extension of status after the expiry of their status, they don't have maintained status during the processing of the subsequent application. That subsequent application should then be refused by the case processing center and respond with a warning notice to the applicant that they are eligible to apply for restoration. The obvious question that kind of arises, and we'll take it into our first question, is if someone files, and this is from a consultant, if someone files an extension application before their permit expires and is on maintained status, can they submit a second in-Canada application after the original permit has expired without paying the restoration fee? I don't know your thoughts on this. The risk to me under the current guidance is if IRCC processes in the order that they are received, which they say that they do, then presumably any subsequent application will wind up being refused because they're out of status without that restoration fee. Is that sort of the risk you see as well?
Yeah. So, I mean, I'm assuming it's an extension. Yeah. So I guess this is assuming that the first application that was filed is going to be refused. And then in that case, yeah, the subsequent one would be automatically refused under the changes, right? But if the first one is approved, I think the new guidance doesn't actually say what happens to the second one.
Oh, that's a good point. And this gets into another scenario that people get concerned about. What if you're trying to cover your bases? You do a work permit extension first, and then you do a visitor record because you're getting nervous. If the work permit extension is approved, but then the visitor extension that followed it is approved, you all of a sudden lose the ability to work. Right? There's just all sorts of weird ways that this can flow with no clear guidance from IRCC.
Yeah.
Or then this is where I was kind of getting to, like just updating the first application and whether it's still possible to do that. There's all sorts of case law that holds that IRCC has to consider all the requests. So you'll often see people with any LMIA-based work permit, say, filing an in the alternative significant benefit work permit, or just updating the application and what the guidance permits or doesn't permit here.
Yeah. Or it could just be that you would just withdraw the second application if the first one is approved, and you just do that as a matter of practice.
Yep. Before we get into some of the other questions that we got not relating to maintain status, but we were asked to address, any final thoughts on maintain status? No? I'll comment briefly that there seems to be all these reports going around the internet about dummy extensions, which is the idea of submitting an application for something that you aren't qualified for on the basis that you'll benefit from like 10 months of maintained status and continue working. And there's news stories about, whether IRCC is going to be cracking down on these so-called dummy extension applications. I think that a lot of this is misreading an ATIP that Deanna Okanachoff and I discussed on Borderlines, in which a single officer in an email to another officer from 2022 expressed frustration with people doing this and said, wouldn't it be great if we clamped down on this? That's all that was said about the topic. Like there's not, and that ATIP that we produced seems to be the basis for a lot of the stories that are coming out about some sort of a policy to crack down. Just to confirm, like there's no actual policy on this. All this documents seem to be going back to an ATIP that we discussed on Borderlines, which has been a bit misconstrued. We do have a live comment from someone named Canadian APA that is a two-part comment, which actually reproduces some of the legislation, which says that if the period authorized for the stay of a temporary resident is extended, then they retain their status subject to any other conditions imposed during their extended period. I'm not sure. Oh, so there's a follow-up. I was about to say, I'm not sure what your question is, but here's the question. Wouldn't this update be contradicting IRPR, which states that your status is extended during maintained status? So the question, I'm not sure if you're talking about the daisy chaining or not, but it's not immediately clear to me from the regulations, which again, as you just reproduced, states that the period of someone's stay is extended if they apply to extend their stay after the
Expiry date.
Canadian APA continues to write that the program delivery update doesn't make it clear what they specifically mean by the expiry of their status. Yeah, it's all going to come down again. Like people are definitely discussing all the various points of uncertainty around this update. And thanks for pointing out this as well, as that is another section, I guess, that there will be discussion on, is what exactly is meant by the expiry of their status. I read it initially, and I think most people are reading it as when the original status expired. But you're right that there could be a way of interpreting that to be the expiry of their maintained status as well. We have another live comment. This is great. Thanks everyone who's joining in to comment from Hui Gao. If someone applies to extend their study permit before their current permit expires and leaves Canada, later they return back before their current study permit expires, do they still have maintained status? I don't know if you want to take this one. The short answer is they probably were never on maintained status.
Yeah.
Do you want to explain why?
Sure. I actually have someone that's on this right now, that's doing this right now. Yeah, so maintained status basically kicks in when your current status expires in Canada, right? So if you're leaving and coming back in sort of before your current study permit expires, you're still on student status in Canada. And your maintained status would only kick in after your study permit expires, provided that, of course, you've submitted your extension before the expiry date.
Yeah. And I guess now is a good time to also add that nothing that we say here should be relied on as specific legal advice to individuals. These are all statements of how the law works in the general context. Obviously, if you do have a specific question about your circumstances, reach out to someone. Don't don't quote a YouTube live stream in an application that you do or something that you tell CBSA. On to the non-maintained status questions that we received ahead of time. And again, if you do have specific questions or comments about maintained status, these have been great. But the inevitable question that we will always get asked is, what is the quota for CEC draws? Do you want to take it?
Oh, well, I mean, the issue is every person that gets drawn, they'll have accompanying family members, right? And those can range from I don't have anybody coming with me to I have a whole village of people coming with me. So I don't think even the government will know exactly how many people they're going to draw for CEC. I think it's going to be fluid and it's going to change as the year progresses and they draw people with different family sizes.
Yeah, I mean, the only thing I'd add is that they will work backwards. So I'm just pulling up
The in Canada focus, right?
the in Canada focus in the 2025 to 2027 levels plan says that they plan on granting permanent residence to 82,980 people in the in Canada process, which is primarily the CEC. It may also include some of the other programs, but mainly the CEC. As Nicole said, though, that includes dependents, and that's admissions, not ITAs. I'll minimize that. The next question, similarly, what is the plan for CEC candidates above 500? Will 503 points be enough? What do you think? This is pure prediction, by the way. We don't have a crystal ball.
We don't have a crystal ball. That's the $1,000,000 question. I think if anybody knows the answer to that, that is the $1,000,000 question. I don't feel like I can answer that, Stephen.
Yeah. I think it will be tricky under the current levels plan. The big question, of course, will just be there's a new government. Do they feel like they have to stick to the levels plan? So far, they have said that they will. But when push comes to shove, there's a lot of grumbling about the impact of other programs and categories, say, on the overall CEC. And whether they start to adjust things as the year goes on remains to be seen. If things do not change, 503 points this year will be difficult. And then you can just go into future years in the levels plan and sort of try to do the math as there, in theory, will be less temporary workers in Canada, but this is also going to be offset by a reduction in the CEC targets each year to accompany and accommodate to an extent the increase in Francophone and other programs. Last question that we got was, and it's sort of related to the others, I know an American religious worker, they've been in Canada for 20 years, they couldn't renew their work permit and they had to leave. Is Canada trying to make all people with work permits leave?
I had a client in a similar situation where I think the refusal reason was because IRCC thought that they had been here for so long and they weren't applying for PR status, but somehow they were concerned that this person would not go back to their home country, even though they hadn't been applying for PR. It was a very confusing refusal. We actually ended up doing another application for this person with further facts and arguments, and they got their new work permit. Yeah, I don't know if you've seen anything similar, Stephen.
I think the general sentiment, we just got back from the Canadian Bar Association annual conference in Victoria that Nicole helped organize. Good job. Is that a Twitter logo or so? But what the general sentiment is, look, IRCC is trying to get to 7% foreign nationals in Canada or temporary residents, workers, students, as they're defining it, to 5. The only way they can do that is by refusing a lot of people and those people leaving. Although in theory, the way that they count this, if people are here without status, they're not counted as temporary residents under the government's formula. So really the only way to get to that number is either grant permanent residence to a lot of people, which they have indicated they're not going to do, or refuse people. So that does seem to be the trend. We only have a few minutes left. We do have more comments coming in. The first is I have planned to gain foreign work experience by going back to my home country and gaining 1 year of foreign work experience. This will increase my score by 50. Is it a good idea? It's not a question we can offer or answer on this. That's super personalized to you and something you should speak to a representative, or also just really like consider going back versus staying in Canada. That's a very personalized question. And I think this will be the last one. Karen on YouTube says, thanks for the live stream. If a student applies for a postgraduate work permit in Canada, but is not eligible to start working under 186W, but they applied for the PGWP, was their study permit was valid, and they leave Canada and re-enter after their study permit is invalid, do they benefit from maintained status? Would the situation be different if they returned while their study permit was valid? And once again, as Nicole mentioned, if you return before your study permit is expired, you will still get maintained status. There are, so 186W, for those who don't know, I'll just quickly type it in. I'm not aware of a situation where someone would be ineligible. Well, I guess if they didn't maintain full-time status during their program or not. But for those who don't know, I'll throw 186W. We can just read it. I don't know if we'll have a firm answer on this question or not, but let's have a look just because it's a pretty detailed question. 186W is another way to get maintained status. It provides that a foreign national can work without a work permit if they are or were the holder of a study permit and they completed their program of study. They met the requirements of being a full-time student and not exceeding their authorized work during their coursework, and they applied for the work permit before the expiry of that study permit. So I would have to know the specific reasons why they don't think that they're eligible for a postgraduate work permit. I have never seen someone, for example, if they didn't maintain the full-time, if there's a technical refusal due to full-time status, say, I still find that I have not seen people penalized for working on this, but again, you might want to just reach out to someone to fully answer your question as to why they actually aren't eligible for the postgraduate work permit. I don't know if you have any final thoughts on that before we wrap it up.
Yeah, like I would echo, I mean, if you applied for your postgrad before your study permit expired, it's really rare for us to see situations where 186W would not apply. And yeah, you should reach out and tell someone your specific fact details so that they can help.
And 186W, by the way, applies to any work permit. It's not just postgraduate work permit. So if someone's
That's
applying
true.
for an LMIA-based work permit while they were after graduating, it's just, this is a common misconception, is all they have to do is have applied for a work permit and a decision has not yet been made. So the ability to benefit from it is pretty broad. But okay, we've gone a little bit over. Thanks everyone who asked questions. That was great. We do plan on doing these Mondays. We haven't picked next week's topic yet, but if you want to join in these discussions, please feel free to do so.